Hi, I'm Greg McLawsen. I'm the Affidavit of Support lawyer. I represent green card holders in federal lawsuits to enforce the Affidavit of Support, and I serve as a consulting expert when the Affidavit of Support is litigated in family court proceedings. I wanted to talk about whether a daughter or son of a sponsored immigrant can enforce the affidavit. So here's a common scenario. The Affidavit of Support, not always, but usually comes up as an issue when a couple is getting divorced. So most often in these cases, you have a U.S. citizen who has sponsored a foreign national through the immigration process. Things later fall apart, and often during the divorce process is when the foreign national considers enforcing her rights under the Affidavit of Support. If that foreign national, the green card holder, has children, can they be part of the enforcement action with respect to the Affidavit of Support? Well, that question was answered in the Erler v. Erler case out of the Ninth Circuit Court of Appeals. The Ninth Circuit pertains to the west coast of the United States, states like California, Washington, Oregon, Arizona. And the Erler case looked at the issue of who is a member of the household for purposes of Affidavit of Support sponsorship. Because if you look at the statute, it determines the sponsor's duty in terms of maintaining maintaining the income of an individual at a limit equal to 125% of the poverty guideline. So who is a member of that household that gets supported? That was the question in Erler. The way the Ninth Circuit answered it was that only individuals who are listed on an Affidavit of Support qualify as household members for purposes of sponsorship. So put differently, applying the Ninth Circuit's decision, an individual has rights in terms of financial rights under the Affidavit of Support only if they were listed on an Affidavit of Support. If they weren't, then they do not have rights under the Affidavit of Support. Let me show you how that works in a couple different scenarios. So if that couple that we were just talking about had a child together after the green card holder obtained residency and came to the United States, that child born here in the United States would be a United States citizen because we have birthright citizenship in the United States. As such, we know that they would not have been listed as a beneficiary on an Affidavit of Support. And so if we have a situation where it's mom and her U.S. citizen child, mom has a household of one for purposes of financial support under the Affidavit of Support. Child doesn't count as a member of that household. Now, the child might very well have entitlement to child support under state family law. That's a totally different issue. I'm just talking about the federal rights under the Affidavit of Support. A different situation is if we have a, let's say, U.S. green card holder who sponsors somebody to come to the United States. In that case, let's just still say mom. Mom, the foreign national, brings two children from a former relationship. Those two children might be part, or would be, if they came in that scenario, would be part of mom's visa case. And they would be listed as intending immigrants on mom's Affidavit of Support form. It's similar but slightly different if you had a U.S. citizen who was doing that sponsorship. In that case, the U.S. citizen, because of what's called the immediate relative category, would have to fill out different I-130 petitions for mom and mom's two kids. Mom and the two kids would each get their own I-864 form, but the result is the same. In both of those situations, mom and the two children would all three be sponsored immigrants under the Affidavit of Support, and they would all have rights to enforce the affidavit. This is a topic that's covered in other videos. In states like Texas and California, mom can enforce the Affidavit of Support in family law proceedings, and the judgment that can be given by the family law court should include a level of support in those scenarios we just mentioned that's for a three-person, not one-person household. Now, you could have a completely different scenario where a child and daughter might have the ability to enforce the Affidavit of Support completely apart from mom's involvement. So let's go through that scenario where it's a U.S. citizen as sponsor. So that means there are different affidavits of support for the kids and mom. What about a scenario where mom's going through the divorce process, the child is now an adult or over age 18, not living with mom. That child has her own affidavit of support. The child, in her own right, could enforce the affidavit of support as against the sponsor, regardless of what mom's doing. So you might have a situation where mom's income is okay. Maybe mom's in a stable employment situation. Maybe there's not even anything at issue in the divorce case and it's proceeding along its standard course. The daughter, who has her own rights under the affidavit of support, can bring her own federal enforcement lawsuit to enforce her rights to support under the affidavit of support, totally regardless of what mom's doing. That could theoretically also be the case where you have minors, but usually in that scenario it's going to make more sense for them to combine their case with mom. But the bottom line here, again, this is under the Ninth Circuit's decision, which doesn't have to be followed by other federal courts, but is the most definitive case on this issue. Under the Erler case, a party has rights under the affidavit of support if they were listed as a beneficiary on the affidavit of support. If they're on the affidavit of support, they're part of the household. There might be different procedural ways that they might consider enforcing their affidavit of support, but one way or the other, they have rights that can be enforced against the sponsor.